Good afternoon. Welcome to the Long Live Third Parties podcast. Free Press, Media Press, Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Prestia versus O'Connor, 178F3D86, Court of Appeals, Second Circuit, 1999. Friends, today we're going to talk about the Conservative Party today. If you're a conservative in nature, you'll enjoy it. If you're progressive in nature, you can enjoy it too. Yes, friends, we may be talking about the Conservative Party today, so if you're not conservative, don't let this alienate you, because the good fight of ballot access, whether fought by conservative parties or by progressive parties, helps progressives and conservatives alike. I'm starting to see the Conservative Party pop up in these cases. It also says here, Michael Prestia, the individual named in the title of the case, represented himself pro se. Usually, in these ballot access cases that I've seen so far, the parties get counsel to represent them. Depending on your circumstances, depending on your strategy, depending on your individual desires and abilities, counsel may or may not be your best bet. I do applaud Michael Prestia for representing himself pro se. You can win pro se. I've heard a lot of people say the system is against you if you're pro se. A lot of people say the system is against you if you're third parties. This may or may not be true. The truth is, whatever the obstacles, we can win. I'm not going to guarantee you will win, but we can win. I myself won a pro se trial back in 2003. This wasn't related to third parties, at least not directly, as it wasn't a ballot access case, but I was picketing, and it did represent the Autonomy Party in an indirect way. So I won my case. The judge declared I was acquitted. I didn't do what they said I did. So friends, let that inspire you when you fight ballot access trials. If you feel the need to represent yourself pro se, do that, and you may win. So let's read specifically what happened here. It says, quote, "This appeal presents the question of whether our holding in Rockefeller versus Powell's 78F3D44, Second Circuit 1996, that freedoms of speech and association guaranteed by the First and 14th Amendments were violated by the New York signatures requirement for petitions for access to the 1996 Republican presidential primary ballots applies to a numerically identical signature requirement for access to congressional primary ballots. Plaintiffs who are members of the Conservative Party of New York, CP, appealed pro se from the order and judgment of the United States District Court for the Eastern District of New York. David G. Trager, judge, denying their motion for a preliminary injunction and dismissing their complaint, which arose out of the rejection of a petition for opportunity to a ballot. That is, an opportunity to write in the name of a candidate or candidates who need not be specified. On the primary ballot for selection of CP's candidate for member of the United States House of Representatives from New York's 7th Constituent District, New York Election Law 6-164. End quote. Once again, they are invoking the First and 14th Amendments. More often than not, our friends are doing so. It's almost to the point where we can assume that argument will be invoked. We love that. We love the First Amendment, and the 14th Amendment is a great amendment as well. Free Press, Media Press, Inc. exists to advance the First Amendment. Therefore, we advance ballot access cases like this. On the issue of pro se, the book the Nolo book, How to Defend Yourself in Court, as well as other legal experts, recommend only representing yourself pro se in civil cases. In my case, it was a criminal case, and it worked out. I wouldn't necessarily advise you to do the same thing. I wouldn't demand it, but if you want to, you may. This is a civil case, so it's a prime opportunity for pro se. If you are distinguishing between a civil case and a criminal case, and you have a civil case, you can do pro se. There's less risk for that. In this case, our Conservative Party friends are not going to go to jail if they lose. They're not going to lose any money. Unfortunately, if they lose, they're not going to get ballot access. So they might weigh that versus how much a council would help them gain ballot access. They chose pro se, and we're going to assume they had good reasons for that, just as myself and others have had good reasons for representing ourselves pro se. They talk about the fairness of this requirement of 5% signatures on the ballots of voters. And it says here the Conservative Party would have needed 140 signatures. How do they rule in the end? They say, quote, "For the foregoing reasons, we agree with the District Court that the signature requirement of NE Election Law 6-1362G does not violate freedoms of speech or association protected by the First and 14th Amendments. Accordingly, we affirm that the District Court's order denying plaintiff's motion for a preliminary injunction and its judgment dismissing the complaint." End quote. Our friends at the Conservative Party did not win, but we give them a top level grade for their effort and their wisdom and their tenacity. We love this. So long live third parties. Goodbye.